All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Good morning. We are here for oral arguments in case number CV20 0281. This is 3'S v. Scott et al. A couple of housekeeping items before we get started. In more normal times, we would invite you to stand at the podium during your argument. These are not those times. So we invite you to stay seated at council table throughout the proceedings. As you can see, our panel is physically distanced and we've removed our masks just to make it easier for us to communicate with you. You're welcome to remove your mask during argument if you'd like, or you can keep it on if you're more comfortable with that. These proceedings are being video and audio recorded and live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock if you'd like to reserve any portion of that for rebuttal. Also, please keep in mind that we've read the briefs and conference the case this morning, and with that, counsel, you may proceed.
Thank you, Your Honors. I'll probably start by standing, but I'm going to end up sitting down anyway. My name is Adam Decker, and I represent the plaintiff and appellant cross appellee for 3'S LLC. As I was preparing for oral argument, I realized that on our end, we've thrown a lot at the court as far as analysis and...
Excuse me, we haven't started our clock yet for some reason. Okay, go ahead.
As I was preparing for oral argument, I was taking a look at the briefing, which I think was extensive. I think I've probably cited, I counted, I was trying to think about how many cases am I going to be able to have recall about. I think I cited 49 cases. Those are quite a few. But as I looked at and tried to really kind of distill the facts and the analysis and what happened at the lower court, I think what we have is a conflict of law. We have a conflict of a statute that the lower court relied upon in ARS 33-416, which says the record of a grant, deed, or instrument in writing authorized or required to be recorded, which has been duly acknowledged and recorded in the proper county, shall be noticed to all persons of the existence of such grant. That competing with what we've asserted is probably our strongest argument, which is the court's right when there's been inequitable conduct or it's unconscionable for a title holder to a deed to maintain that title, that the court is empowered through rights of equity, through laws of equity, as a court of equity, constructive trust.
I may agree with you. If the deed had been recorded after the transaction between your client and Seaberg, but the deed was recorded before your client tendered any money to Seaberg, correct?
That's correct.
So if we're a notice state, I mean, if it's in the record, why didn't your client do homework before giving money?
Sure. Well, and that leads me to I kind of looked at the main parties here, which was Mr. Finn on behalf of 3'S, Mike Seabrook on behalf of MI Construction, and then Jim Scott on behalf of himself and also the title company. That's a good question, Your Honor, and that's one that's been perplexing. While we are a notice state, that doesn't necessarily mean that simply because somebody has notice of a conveyance or a transaction, that doesn't mean that that transaction can't be unwound if the circumstances call for it. This transaction, what I will say is...
But isn't it Mr. Seabrook's right to unwind that transaction? Why do you get to step into his shoes?
It would be Mr. Seabrook's. It could also be my client's. It's the basis of the analysis is on a constructive trust in favor of one who is truly and equitably entitled to the same. And that under the imposition of a constructive trust, there is no set formula. So there is some latitude here.
You never even got a deed from Mr. Seabrook. I mean, there was never actual a purported transfer of the property to your client. I mean, you tendered money to him with say, okay, here's the money, and then you'll sign me over the deed. And he says, well, actually, we have to go get James because the deed's in his name. And it was never actually transferred to you, right?
That's correct. Seabrook did take the additional steps throughout. And this is why the circumstances through this time period are why I think they demonstrate disputed issues of material fact. It's peculiar behavior by all the parties. Here's what,
Including your client.
oh yeah,
His
here's
behavior's a little peculiar, too.
I admit that. Here's the pros. My client tendered $70,000 and had a discussion about a joint venture. That's $20,000 less than what Seabrook had bought it for 2 years earlier, but it's still within the realm of probably what the market's bearing or what viable consideration would be. What did my client fail to do? How did he make a mistake? Well, he paid $70,000 outside of escrow. Was that justifiable? Maybe. He had a long relationship with Seabrook. Seabrook was building him a property up there, and he was used to giving Seabrook a lot of money. What else did he do? Yeah, he agreed to a purchase price, which was raised by Scott. He agreed to a purchase price of $30,000 in the escrow, which is not what he paid, but in an attempt to kind of sidestep and get cute with the HOA fees, and that was at the direction of Seabrook. So you hang that on. My client could have done a lot of things differently. But when you look at Jim Scott, the only pro he has going for him is the fact that he ended up with the property. There was never a written agreement between him and Seabrook for lot 208. There's never a meeting of the minds. He was a real estate broker who had a relationship both with both with Mike Seabrook, who'd been building him a home as well, and the title company.
Mr. Decker, I'm sorry, I need to take a step back first, because when I was looking at this case recently, it occurred to me we may not have jurisdiction. And I know neither party has raised that, but we always have an obligation to determine our own jurisdiction. And as I look at the record, there was a 54C certification, but not all the parties were resolved because MI was named as a defendant, served, but default was never actually entered against MI. So there's still a remaining defendant outstanding, which would mean we don't have jurisdiction on this case because the 54C certification is not accurate. Do you disagree with that, or have you even given any thought to that?
I have not given thought to that. I know that MI has abandoned any position it had. I don't know that it even filed an answer or a responsive pleading. So I don't even know that MI made an appearance. MI had counsel in the bankruptcy proceeding who I don't think ever formally made an appearance, but at least was engaged in some of the earlier dialogue about the case.
Well, there's a way, assuming I'm correct and I'm not misread the record, we wouldn't have direct appellate jurisdiction, but we can exercise our discretion to exercise our discretion to assert special action jurisdiction. Would you be asking us to do that if it is true that we don't have jurisdiction? Or are you asking us to exercise our special action jurisdiction?
Absolutely, Your Honor. If we fell on that front, as far as that loose end.
If we discover things earlier, we usually would send it back and tell the trial court to enter the proper certifications and then delay that. But since this case had already been delayed once, it was seemed late in the game to do that. So we'll go on now that you've asked us to exercise special action jurisdiction. I'll ask your opponent if they oppose that, and we'll figure out where we go from there.
Okay, sounds good. Thank you. Seabrook, Jim Scott's behavior was peculiar. He made representations to Seabrook that he was to go and sign at the title company, conveying lot 208 to MIJ Homes, their joint venture.
Is there any relationship between Scott and Finn?
No.
They don't know each other.
They didn't until they maybe knew each other and that they both had property there in this subdivision.
But they weren't business partners.
They were not business partners.
They weren't in business together.
They had no contact. I think they both knew that Seabrook was building a home for the other, okay, but they had no dealings about lot 208 until after, really it wasn't until after Finn had given tendered the consideration, opened escrow, and then as escrow was proceeding, learned that he couldn't close escrow without Jim Scott's cooperation.
So
on the
question is,
right,
why does your remedy not lie with Seabrook? Why are you leapfrogging to Scott? And the answer is because Seabrook filed bankruptcy. Is that correct?
Yes, that is an answer to that could be one of the reasons is that
Why didn't your client, 4-3's, a la Finn, go after Seabrook? Seabrook negotiated a sale of a property to which he knew he didn't hold title. Would you agree?
yes, and I think to answer that question is because Seabrook had left the state, was not paying for representation. I guess your point is could there have been an assignment made potentially? I guess I'm trying to see where you're headed and trying to answer your question forthright.
This. If this were a case where 4-3's were suing Seabrook for recovery of the money they tendered for a property that he represented that he owned, that in fact he knew he didn't own, we'd have a different case. But you are suing a third party, Scott, who may have flim-flammed Seabrook, but did not have any direct dealings with your client. So that's what I'm kind of having difficulty figuring out.
There'd been no recovery. If it was just a pursuit for the damages against Seabrook, my client never would have recovered anything against Seabrook for any of those funds. There wouldn't have been a recovery. The remedy lied in with the property. My client wanted the property. He didn't want to chase Seabrook around for another 20 years to collect $70,000. And the theory is, or again, we contend that the constructive trust gets my client to the table, at least to have that discussion, so that the trial court can take a look at what all the parties did and did not do and conclude who should end up with the property.
Do you have a case ever in Arizona where defendant, in this case, it's not the defendant, but the person being Seabrook sold property to one person under any circumstances, and then subsequently sold that party to a second person, and the court has said, oh no, you get that property. The second person gets that property. I'm just having a hard time imagining. I understand your arguments about equitable relief and constructive trust, but we don't have a notice then. I mean, we're not a notice state anymore if you can just say, well, the second person, despite notice, despite that deed being recorded, still gets the property.
With the second person, I think these facts may not be directly as the hypothetical you just provided, Your Honor, but in the Young versus Lujan case, mom dies.
What's the site for that one again?
That is 461 P second 691.
I don't use P second site. So what's the Arizona?
11 site? Arizona APP 47.
11 Arizona app for what?
47. It's a 1969 case. And then another strong case that we find that we think supports this is Turley versus Ethington. That is 213 Ariz 640. It's a 2006 case. But in Young, mom dies, son gets the property. I'm trying to think of the hypothetical if it was conveyed to son or if son sold it. He didn't sell it as the administrator because there was one subsequent to that. But son sells the property to some innocent buyers, bona fide purchasers. Mm-hmm. And the heirs and the administrators, is that the right? I'm not probate, but whatever it is.
Yes.
Yeah, the representative of the estate then sues to unwind that deal. And you had bona fide purchasers sitting there saying, well, we bought this for value. We didn't know about all the problems. But the heir said son had no right to convey the property. And so that deal, the constructive trust is formed and it was unwound. On Turley, you've got husband and wife who do an oral agreement with uncle and aunt to buy property, and that after uncle and aunt buys the property, they will deed it the 1/2 interest to husband and wife. Uncle and aunt buy the property. They decide, well, we're not going to deed it to husband and wife. Husband and wife sue, again, based on an oral agreement, nothing in writing, and the court there imposed a constructive trust.
You see the difference, right? In neither of those cases do you cite, you have a third party getting it, you have the seller getting it back from the buyer, but you never have a third party getting it back from the buyer independent of the seller. And that seems to be very different. I mean, if I sold you a property and you record that deed and it turns out your check bounces, I might have a remedy against you,
Yeah. Well, you might.
to unwind that deal.
Okay.
But if then I turn around and sell it to another third party, I don't know that they have a remedy to go and get that.
Well,
check.
I see where you're going,
Yeah.
but again, that presupposes that the original deal is valid. think
I don't know, even if the check bounced, I don't know that the third, and I then decide, well, I'm just going to sell it to a third party despite the fact the deed's recorded. Would they have a right to go and get that?
They would if the seller never intended or never thought they actually sold the property to the initial buyer.
Huh.
If the initial seller, Finn could have done a lot more. He could have opened escrow. He could have confirmed.
He could have run a title search.
Yeah, he could have. I mean, it was 8 days later, so I don't know what would or would not have popped with the county recorder. The title company wasn't concerned about the escrow. I mean, they opened the escrow. They knew that the property didn't belong to Seabrook anymore, to MI Construction. They knew it belonged to Scott. That's a perplexing issue for me. Why would the title company say, hey, we're going to go ahead and open escrow for a seller who doesn't own the property to a buyer who's completely unrelated to Jim Scott? The joke was, hey, I got a bridge to sell you, right? I mean, here's a Golden Gate Bridge or Brooklyn, whatever it was. But in this case, the title company is saying, yeah, we'll go ahead and we're going to open escrow. Well, why would they do that? The discussion with the title company to Scott was peculiar. Hey, we need you to come in and convey that deed back over or to sign it. And Scott's reaction was not, I bought this property. What are you talking about? It was, I'm not in a position to sign that right now. The same thing when he communicated with the title company. Scott didn't open an escrow. Scott didn't do a title. I mean, he didn't need to do a title search. He didn't open an escrow. He said, give me 2 deeds. One that I'll take title right now from MI Construction, and then one, wink, wink, Rucker, the title company officer, I'll send back to you after Seabrook's obligations to me are satisfied. And the title company said, sure, okay, we'll do because we know you so well, we'll do a recording for you. We'll do you a solid. We'll record the deed. Here's the recorded one. Here's the draft. Kick that back over to us once you're all settled up with Seabrook. So it's just a peculiar set of facts. But our contention is that Jim Scott acted egregiously. Seabrook all along wanted to sell it to Finn. If he didn't, he would have kept the money and taken off instead of sticking around for 3 weeks trying to close a deal, calling Jim Scott, trying to get everybody on the same page. And probably the most heinous thing about all this is the fact that consideration that Scott offered to Seabrook, he never even tendered it to Seabrook personally. Because they had this construction relationship, he went down to the MI Construction's bank account, put in a check for, I think it was like $25,000 or $30,000, right, for lot 208. And Seabrook, why is Seabrook bankrupt? He had no idea the check was even deposited until 2 years later at the time of his deposition. So there's a lot of squirrely things going on here, Your Honors. But our contention all along has been that, yes, 33-416 exists. And yes, that should be there to protect valid instruments. But if it's an invalid instrument from the beginning, that law, that statute should not be there to undermine a valid claim for somebody who offered consideration is trying to purchase the property. But it's going to be based upon the circumstances. There'll be others. There may be one so far removed that's just not it doesn't make sense. But in this case, with all the circumstances over a 2-week period, my client should have his day in trial. And I'll reserve 2 minutes 40 for a rebuttal.
Thank you.
Good morning, Your Honors. My name is John Carlson. I represent the appellee, cross-appellant, Jim and Michelle Scott. So I think we've already kind of started talking about where my argument is going to go, and I'm going to keep it probably my remarks short and simple. So obviously I'm here to answer questions that we have, and to just respond to kind of where Mr. Decker just ended off. It's our position, in how it's kind of been reflected already here, that those facts leading up to the Scott deed are irrelevant here. It's Scott and Finn at no point had any contact prior to this deed. They were not in privity. There's no discussions between those two. By the time Seabrook started talking with Finn and really formulating any kind of potential oral agreement for the sale of the property. The deed here was recorded on April 18th, I think, and I think the funds that Finn ended up paying was a couple weeks later, April 29th, and escrow opened maybe there a couple days thereafter. And as we've discussed, at no point did Finn go and tell title to, hey, protect me in this matter like you normally would, didn't put the money through escrow, paid outside of escrow. It didn't get the title report till several weeks after he's already paid this money. And so it's truly a circumstance that Finn caused his own harm, and Seabrook.
I don't know that. I mean, he may have been negligent in what he did. But he didn't cause the harm here, at least as.
Yeah, maybe that's not the way of saying it. Scott was not the person who caused Finn harm. It was, if anybody, was Seabrook, and it is the court's identified in some of its questions already, is that if there was a remedy for Finn, it lied with Seabrook, and there's not any kind of law that I'm aware of that somehow that liability transferred from Seabrook to Scott, despite some of the cases in things cited here. And I'll just respond to the two that were named by Mr. Decker here today, and these points were made in our briefs as well. But in the Young v. Lujan case, the complainant in that case was the administratrix who was the successor in interest to the original owner, who was the person defrauded out of the property. And so it has little bearing to this case. And then in Turley v. Ethington, the uncle and aunt and husband and wife, they got together, had the court found had an oral partnership agreement for the purchase of these properties, and then they were going to deal with those properties and sell them, subdivide them and sell them out. And so the court found that there was a prior interest there. It stems from the oral partnership agreement to purchase the properties. And so when the court found a constructive trust, they were saying that the husband and wife, who were the complainants in that case, had a prior interest to the properties. So I think those are distinguishable cases, and go to the point that on the constructive trust point that Mr. Decker's arguing Finn had is a truly an equitable owner, so you can impose a constructive trust in this case. And it's just tough to reach that conclusion when Finn at no point had a deed to him from Seabrook, an assignment of interest. There was, at most, there was an oral agreement to purchase the property, but all of that came after the April 18th deed to from Seabrook or MI Construction to Scott. And so for those reasons, we don't see a constructive trust being an appropriate remedy as far as Finn v. Scott. And as far as argument on the primary appeal here, that's primarily what I had to say, and I wanted to respond to Mr. Decker. I'll transition over to our cross appeal arguments, and of course leave as much time left as questions as the court desires. But moving to our cross appeal, so the summary judgment was found in favor of all claims, and that included Scott's claim under ARS 33420A for the recording of a groundless document, in this case a lis pendens and an affidavit were both recorded against the property. Court found in favor of Mr. Scott in this instance. And just a simple reading of the statute, anytime there's a groundless lien found, the person purporting to claim that interest who filed the groundless lien, in the language, it couldn't be more clear, is liable to the owner or beneficial title holder for the sum of not less than $5,000 or for treble damages of the recording, whichever is greater, and reasonable attorney's fees and costs of the action. And so,
is the court's ruling that it's setting aside the lien, but also then not granting you fees, is there any way in which we could, because we are obliged to affirm on any basis that is supported by the record. So looking at that, could we find that the court found that the lien was invalid, but not necessarily groundless, and therefore you wouldn't be entitled to fees?
I don't believe so. I think the law, when looking at some of the cases, and they're not a ton that are addressing this statute, but if you find the lien groundless, it should follow then that you have the damages.
Does the court's judgment on your counterclaim under 33-420 explicitly state that the lien was groundless?
I don't know specifically. I don't have that directly in front of me. If I remember right, I don't think it says is groundless. I think it is liable under the statute.
And the elements of that offense under 420 are that is groundless.
Yes. Yeah. And so and I think one of the cases cited in Mr. Decker's briefs on this issue is Fagerly, which kind of speaks to that issue, is that the court was not, once it found that it was groundless or was not groundless in that case, there was no liability stemming at all. And so the question of whether it's groundless or whether there's liability under 420A is the threshold issue. Once that's found, you have the statutory damages and the reasonable fees here. And that's, and so that's our position in this. And I won't go into necessarily all the arguments on Mr. Decker's point raised in the briefs. I think we responded to it well in our reply, but when the language is clear in the statute, there's not, you shouldn't go and try to finagle out different meanings in different organizations of the words, and we hold or believe that is liable is about as clear and unambiguous as you can get to imposing liability. So with that, again, I didn't have a much prepared remarks, so if there's no other questions, I'll cede my time back to the court.
Okay, thank you.
You want to check on the special action?
Oh, yes.
Oh, yeah, I'm sorry.
Yeah.
I assume you don't oppose us exercising special action jurisdiction?
No, yeah, it'll just be back up here again if we don't. So.
Okay. Great. Thank you for reminding me, counsel.
You bet. From the Turley case, a constructive trust is an equitable doctrine that prevents one person from being unjustly enriched. That would be Scott in this case, at the expense of another, which would be 4'3's or Finn in this case. Seabrook didn't, there was no expense from Seabrook in this case. To the contrary, he was paid twice for this property. It arises by operational law.
But Seabrook was the one who was unjustly enriched. I mean, Scott paid something for it. It might be that he should have paid more, but he paid money for it, and it's Seabrook who's the one who got paid twice.
Well,
so wasn't he the one who was unjustly enriched?
They both could have been. I mean, there's an argument that they were both unjustly enriched. One got paid twice, and Scott ended up with property at a bargain price.
I get you. I understand your argument, counsel, but it seems like Seabrook has the constructive trust remedy as to Scott, and you guys have a constructive trust remedy as to Seabrook. I'm having trouble getting Turley to say that you guys have a constructive trust remedy as to Scott.
Well, it's an equitable remedy with no set or unyielding formula. There's great latitude here, and it doesn't talk about a direct. It doesn't mention anything about. This is why it's a case of first impression in my perspective. And it doesn't talk about. I'll abandon that. Let's go to the attorney's case issue. ARS 12-1103. That's the quiet title action. Those fees are discretionary, so clearly the trial court was in its was within its right to say we're not awarding fees there. ARS 33-420, A, B, and C all deal with different scenarios. With C, the language is different in each concerning attorney's fees. B is when you have a special action, and I think it is discretionary. It says may. C says automatic as a penalty when you send a letter for a wrongful lien or wrongful recording. It's automatic. A, it's not that clear as it is in C. And so when I'm trying to reconcile what did the lower court do, I have the same dilemma. But what I think it did is it concluded that if there's a good faith basis for the recording, then it doesn't have to impose both the attorney's fees hammer and also the statutory hammer. Anyway, that's all I got. Those are my final points. Thanks.
All right, thank you.
Council, we thank you both for your arguments. You've given us much to think about. We'll take the matter under advisement, issue a ruling in due course, and we are adjourned.
Thank you.